to Legally Speaking with me, Tarun Nandia. Today we're going to discuss the Satyendra Kumar Antil judgment, also how it's being complied with in various states and so on. Why it is so important, why bail and liberty is so important, and how Justice Sanjay Kishan Kaul has upheld liberty in a sense where these values are cherished by us all. And only when liberty is taken away do we realize how important these values are in a democracy. And in a sense, Justice Sanjay Kishan Kaul has shown the way. That's why we take this issue up today. May I welcome my panel today. I have with me Niharika Karanjawala. She is with Karanjawala and Company. I have with me Abhimanyu Bhandari. He's an advocate at the Supreme Court of India and the Delhi High Court. I have with me Manmeet Singh. He's partner with Saraf and Partners. Good to see you all. And at the outset, may I request Abhimanyu in the first 2 minutes, could you lay the ground of the issue before we move ahead?
Okay, thank you, Tarun. So Tarun, first, let me just explain to you what this Antil judgment is all about. The problem that we were facing in many states all around the country was that there are a large number of cases where an investigating agency, while it is investigating a crime, decides not to arrest an accused. Do remember that an accused need not be arrested unless the investigating agency feels that for some reason they need his custodial interrogation. If the investigating agency decides, whether it's the police, whether it's the CBI, whether it's the ED, any investigating agency, investigating a crime decides that, look, here we don't want the accused in custody, and we've investigated the matter and we are happy to file a charge sheet against that accused, then in that sense, the person should not be sent to behind bars or taken into custody even for 1 day, because the agencies have said that we don't need his custody. Now, in most of the economic offenses, Tarun, the main accused is usually arrested because they need his custodial interrogation. He applies for bail. Whether he gets bail, doesn't get bail is a separate matter. But then with a charge sheet that is filed against the main accused, often there are other accused who may have played a lesser role, who may have been ancillary to the main crime, or maybe accused whose custody the investigating agency decides not, that they don't need. Or even after filing a charge sheet, when an additional complaint or a charge sheet is filed, what we call a supplementary charge sheet or a supplementary complaint, in that new accused may be added, who the investigating agency may have added because they may have conspired with the main accused to commit the crime or for various other reasons. But the investigating agency decides we don't need that accused's custody. However, the problem that is arisen, Tarun, was that in large number of courts around the country, when the charge sheet is presented, the accused has to appear. When that accused used to appear, then he would be taken into custody, notwithstanding that he was never arrested during investigation. The court, for the first time, and I think this Antil judgment in the last 2 decades is one of the most important judgments in the bail jurisprudence, because it is for the first time that the court said that, look, if a person is being presented, and of course, Antil followed Siddharth versus UP and Amanpreet Rahi. Both were 2021 judgments by the same honorable judge who was the lead judge even in this judgment. And the Supreme Court came to the rescue of such persons and said that, look, if the person is presented before the special court or any court, if he's an accused and he was not taken into custody, then you need not take him into custody. The word custody under section 170 of the CRPC was read down as just a presentation of the accused before the trial court. And the accused could furnish his bail bonds and go back home and face trial. And this clarification and this judgment that the Supreme Court got was groundbreaking, because Tarun, as you're aware, in your shows, you've seen that a large number of these economic offenses, a lot of people are roped into the charge sheet. And there is no need to even send them for 1 day of custody. Yes, if tomorrow they get convicted by a trial court after a trial, then of course, but no one should face even 1 day of custody if that person is innocent. Until a trial is completed, a person is innocent. Do remember that taking somebody into custody is an exception. The general rule is that you're not supposed to take anybody in custody, and you should present the charge sheet and let the trial court decide whether that person has committed the crime or not. So Antil comes as a very big rescue by saying that the court should ensure that people are not taken into custody and they can give their bail bonds and they can go back. They need not surrender and be taken into judicial custody. Now, having said that, Tarun, my personal experience has been that in a large number of cases, what happened was that accused persons would start filing anticipatory bail because everybody was worried that, look, charge sheet has been filed, we would go to court and the court would, in a mechanical manner, take us into custody because charge sheet has been filed. And then I would be left to the mercy of going to the High Court or to the Sessions Court to try and get bail. Or even in that court, if I had to move a bail, I would move a bail, then the prosecutor would file a reply, and then it would, for those days, I would spend in judicial custody. So to avoid that, accused persons started filing anticipatory bail. Because when you file an anticipatory bail, you yourself don't have to go to court. To tell the court that, look, I have not been arrested during investigation and I should be granted anticipatory bail. Now, in a large number of these cases, those anticipatory bails also got dismissed because the courts started saying that Antil talks about bail, regular bail, not about anticipatory bail. Therefore, the principle in Antil should not apply to anticipatory bail. Thankfully, on 21st of March, in the same judgment, Antil, which is an ongoing matter, and the court is monitoring whether its principle that people should be allowed to go back and give bail bonds. In that matter itself, the court has now clarified that anticipatory bail with common sense is a species of normal bail. So therefore, the principle of Antil would also apply in anticipatory bail. And Tarun, this is going to be groundbreaking. It's going to be groundbreaking because a lot of people who feel that the courts in various parts of the country are not implementing the principle in Antil would be able to go and now file an anticipatory bail and tell the court that, look, I should be put on anticipatory bail because my custodial interrogation is not required by the investigating agency. Especially in PMLA cases where, we see in supplementary complaint, large number of accused coming in. The fashion has been to rope in everybody, even an innocent holder of proceeds of crime being roped in. That's what's become the situation where we see a number of accused persons just being roped in supplementary charge sheets. So therefore, in today's time, this judgment plays a very critical role. And what is even better is that Supreme Court is now monitoring and ensuring that Antil is implemented. It is asking for various states to file compliance report, whether the trial courts are implementing or not. Rather, there's a paragraph in the last order of 21st March 2023 where the court has come down heavily and said that, look, high courts will have to file their compliance reports, and has also said that the trial court should read Antil and implement it, and have frowned upon the fashion, the trend where in some cases and in some courts, Antil is just not being implemented. I don't want to name the courts, those particular states as mentioned in the order, but my personal experience has been that while Delhi and Mumbai courts I've seen have rigorously implemented Antil, is what I feel in most of the cases, and they have noted Antil and they've applied Antil, especially Bombay and Delhi. I have seen that in some parts of UP, it is not being implemented at all. Rather, people are being told to go to High Court. And I find that completely violence with this groundbreaking, great judgment that we have seen in the form of Antil.
Point very well taken, very interestingly. Thanks for explaining this in detail. And of course, Senior Advocate Siddharth Malhotra was appointed as a amicus to see in report back on what is happening in the states. I'll go across to Niharika Karanjawala from Karanja. Now, your law firm sees a lot of such cases. You engage a lot of lawyers who appear in courts in different forums. What has been your experience and what difference do you think this judgment by Justice Sanjay Kishan Kaul has made and will continue to make in the times to come?
So it certainly made a tremendous difference, Tarun. I couldn't agree with Abhimanyu more that it is one of the most relevant and will continue to remain one of the most relevant cases on bail in the last decade and in the decades to come. One of the major problems is, since bail comes down to such a heavily discretionary issue, it becomes sometimes there's almost an arbitrariness to it, and that is what liberty-oriented judgments like Antil seek to curb. They seek to curb instances where mechanical arrest is simply put forward. Also, another large problem with our prosecution system is there's an adversarial nature between the people on trial and the investigative agencies and the prosecution. Rather than putting forward the investigation, moving forward the investigation and the trial, it is almost a challenge to see how long you can keep someone in custody. It's very adversarial. Therefore, these agencies themselves need to accept that a change needs to be brought in the way they are approaching these things. Bail, whenever applied for, is routinely opposed. Whether custodial interrogation is required or not, it is routinely opposed because that is simply the way things are done, and that is the way things have been done for quite a while. And people tend to cling to the things they know. As Abhimanyu mentioned, in other states also, part of the reason why judgments like Antil are not properly implemented, I believe there was an issue with implementation of the Arnesh Kumar judgment also, is because people stick with this notion of, well, this is how we do things here. We don't know how you do things in the Supreme Court, but this is how we do things here, and this is how we've always done things here. And if you have an issue with it, off to the High Court with you, right? Which is something that will take a certain amount of time to be changed, as it is something that requires a lot of compliance by various investigative agencies and by various courts at various levels. But as Abhimanyu mentioned, with the court monitoring this and with the court taking into account the fact that these guidelines are not being properly implemented and frowning upon that notion, it is slowly moving towards a point where the arbitrariness will be taken out of this, and where arrest, hopefully, will only be affected in those instances where it is truly necessary. Because as you know, this judgment has also come to us at a time when the under trial imprisonment situation is out of control. It's the court deals with this right at the very outset. And in fact, as anyone who practices law in this country will know, there are some states where under trial prisoners serve more than the maximum term they would likely have served had they been convicted, because their cases simply get lost in the system. Dates don't come up. You go 10 years without a date coming up, and you're simply living your life within the prison system. A lot of people don't have access to regular legal advice. They don't know what their maximum sentence is. They don't know what rights they have. They have a job in the jail, and their life continues there. And the fact that this is all allowed to happen under trial should be nothing short of shocking to anyone who hears it, right? And it is in light of that judgments like these are really path-breaking on these fronts.
Thanks for explaining it well, and also the situation of under trials and what goes on. I'll take this to Manmeet from Saraf and Partners. Manmeet, you had the litigation team at Saraf. You would be going through many of these kind of cases day in and day out. What has been your experience in the past few years? What do you expect to see post this judgment by Justice Sanjay Kishan Kaur?
I think as Abhimanyu and Niharika have already mentioned, I think this is a path-breaking judgment. One of the aspects of this judgment that I would like to touch about is the direction contained here, that this must be brought to the notice of the agencies and public prosecutors. So they don't follow the adversarial approach that they must oppose bail. If it is falling within the parameters of the law laid down in the Antil judgment, then bail should not be opposed. So I think this is going to lead to a mindset change where bail is routinely opposed, and therefore this will certainly declog the system. And so therefore, Antil, by laying down how bail is to be approached at different stages of the trial process and how Article 21 touchstone must be applied. And as Abhimanyu said, a person should not be put in custody for 1 day unless the requirements stipulated under law are met. I think it is certainly going to be a defining judgment, and it is going to lead to a change in the mindset in the entire system, not just the judges, but also agencies as well as prosecutors. So yes, it is certainly a very progressive judgment, which would definitely go a long way in protecting the rights of accused persons.
Point well taken. I'll go to Advocate Abhimanyu Bhandari. how difficult and onerous a task it is for the Supreme Court to get it implemented in various states. Of course, the Supreme Court is now monitoring the thing. How do you think this will operate, or do you think there are challenges that lie ahead even now?
So, Tarun, just like we have the Antil judgment, I think it was 2009 or 10 when we had Sanjay Chandra versus CBI, which was a landmark judgment of the Supreme Court. I think it was Honorable Justice Dattu sitting with Honorable Justice G.S. Singhvi. G.S. Singhvi was the lead judge. And that was in relation to the 2G cases where the Supreme Court clarified that one investigation is done and charge sheet has been filed, bail should be granted. But many courts did not implement it. But remember, the court was not ensuring implementation at the trial court level. What is great about this time round with the Antil judgment is that the Antil judgment, the court is taking an initiative, the apex court, to ensure that this judgment is sent across the country to various courts, and courts are being made to file compliance reports to show that it is being implemented. And there is a amicus curiae who is assisting the court in ensuring that this process is completed in a time-bound manner. Rather, orders have been passed asking certain officers to be present in court to ensure that they file their reply and their compliance affidavits. The court is taking it very seriously. And according to me, if there were two judgments that I have seen in the last 10 years that have had a real impact on personal liberty, one is, of course, Nikesh Tarachand, and one is this judgment. And both these judgments, Tarun, really, really speak for pro-liberty, and they strike a balance between those who should not be granted bail and those who should be granted bail. Bail is a right, jail is an exception, and these two judgments reinforce that. And I'm quite certain that after Antil, I've seen that there has been a real positive trend where accused persons not investigated, not arrested during investigation, are walking to trial courts with confidence and with bail bonds to go and submit the bail bond. I did a case last week where I advised a client, in a Bombay, in a PMLA matter in ED, in a Bombay case where a lady, a senior citizen, who was never arrested during investigation and found herself in a supplementary charge sheet, went with her counsel to the Bombay court, showed the Antil judgment, and walked away by submitting bail bonds. And that shows the positive impact that this judgment is having in our country. This is what the judgment wanted that court should do, and I see that it is being implemented. The fact that court is again listing this matter, I think after a few weeks, shows the seriousness with which Supreme Court is taking this issue.
Point well taken. I'll take this to Niharika Karanjawala. Niharika, two things is there are multiple FIRs many times. How do you look at this issue panning out in the states? Secondly, how onerous is a task, as I asked the other panelists, to get this implemented? There's a certain rigidity which we see in Uttar Pradesh. We would have seen for 10 months, many businessmen accused are not given bail. How are they to run their business with behind bars for 10 months, 11 months, where it is almost certain for many people that unless they go to High Court, there's no bail that will come. Could you just analyze this for a bit?
Absolutely. Absolutely. I think this is the major challenge faced by bail jurisprudence going forward, because as we can see on paper, the issue is quite fair. There's no arbitrariness in the issue on paper. The Supreme Court has issued 3 tranches of guidelines in this matter. As Abhimanyu said, it's an ongoing matter, and ultimate clarification coming in the July 11th order. On paper, it is all very fair. In practice, however, it's very different, and it is a bit of an onerous state to get people to get investigative agencies to fall in line. Because, like I said, they tend to cling to the way things are always done. However, seeing how seriously the Supreme Court is considering this is something that I think slowly over time, but hopefully within the next decade. I don't think it'll last. I don't think this is something that will linger on for decades, as something that was there on paper but isn't actually implemented, because the Supreme Court has been very hands-on with this, and they are clearly sending out the message that they take this very seriously. They take liberty very seriously, in a series of other judgments as well. Even Honorable Justice Chandrachud also, Chief Justice Chandrachud also had made a statement with regards to how lower courts should not have an apprehension in granting bail. And there are apprehensions because the courts themselves sometimes come under severe criticism from the public in general. And I think all of these statements coming together from the apex court of the land will clarify the situation to the investigative agencies and to the courts in various states that this is a step that benefits not only the individual. And if it was something that only benefited the individual, Tarun, it would still be worth it, because liberty is too high a price for us to compromise on. It is too high a price to pay in the aid of convenience of investigation or anything like that. It's simply too high a price. But this is not only something that helps the individual who is at the steps of the court for justice. This is also something that helps the system in general, because when people are convinced that a system is not going to treat them with arbitrariness or unfairness, and they are not suddenly without cause or without warning going to find themselves thrown in jail for 10 months, unable to operate their businesses, barely able to see their families, as you said, it will only incentivize them to cooperate further with the investigation, and it will ensure that people don't hold back in any sense of the term from giving their full cooperation to the investigative agencies and to the cause of a speedy and just trial. Furthermore, when it comes to multiple FIRs, as you said, that is a huge stumbling block, because you secure bail in one FIR and bam, you can be arrested in another. That is also certainly something that needs to be looked at and something that needs to be ironed out. And like I said, once the adversarial nature is taken out of investigations and taken out of prosecutions, and that will take longer. That will take much longer than simply implementing guidelines that the Supreme Court has laid down, because that will need to be a whole outlook change, which will be difficult. But once that is properly implemented, it won't be such a gotcha kind of thing, like, oh, okay, you got bail on this, all right, other agencies come in and arrest you the next day. It'll take some of the sting out of that. And that'll also improve our prison system manifold, because if someone is not required for custodial interrogation, frankly, or if there is no apprehension of them either fleeing from justice or interfering with the trial or evidence or witnesses in any way, because those are parameters to be considered, then frankly, their presence in a jail does nothing more than clutter up that jail. And our jails are already overstuffed, they are overextended, and especially coming out of a pandemic, we see how this is a very, very real situation that needs to be diffused soon.
Point well taken. We are short of time, so we go on to round of closing comments. We'll start with Manmeet. Manmeet, I have seen many times that many high-profile accused businessmen, they would say that all the acts of commission or omission which are alleged to have been done by me are on paper. Then why I am being arrested? If all evidence is on paper, is there a need to keep me in jail? And it's a very genuine submission that they make, many of these businessmen who then want to get arrested. And they say that arresting the businessman will only serve one purpose, that the business will be run to the ground, the employees may not be paid salaries, and the bank loans, if at all, may not be paid. Can you reflect on this in your closing comment?
You're absolutely right. In fact, particularly economic offenses, most of the evidence is documentary in nature. Transactions have happened from the bank accounts. In sophisticated businesses, you would find that all correspondence, if not all, would be on email servers, etc. So most of the correspondence, evidence, etc., is all documentary. And therefore, for that reason also, custodial interrogation is, in most of the cases, not required. And as Abhimanyu said, in a lot of these cases, what happens is a large number of people get named. A lot of them are not arrested, but yes, even the ones who are arrested, the agencies and courts do need to take into mind. Now, economic offenses have got classified as a separate offense, and they are looked at upon differently as threatening the economic integrity of the country, etc. But fact is that in a lot of these, the evidence is mostly documentary, right? It is available. It can be seized right up front. And therefore, there is no real requirement, as long as you are not as long as the agency is convinced that there is no threat to destruction of evidence and the parameters otherwise which apply are not there, courts should be granting bail in those circumstances. And I think the Antil judgment with its directions that if the magistrates are not implementing the judgment, then the high courts can go so far as to even withdraw the judicial business and also require training in appropriate cases. It would certainly make a difference to economic offences in particular.
Okay, so it's strong action needed to ensure pro-liberty stance is followed. I'll go to Abhimanyu Bhandari for his closing comment. You're not audible.
Sorry, Tarun, my closing comment would be a more general comment. I think this judgment is a watershed in the jurisprudence dealing with bail. Let me tell you, Tarun, we saw how Nikesh Tarachand was a very progressive judgment, which spoke about that, time has come to do away with rigorous twin conditions in the bail jurisprudence, which says that the court has to be satisfied that the offense has not been committed before granting someone bail. Yes, of course, that judgment finds that judgment now has been overtaken by Vijay Madan Lal, where it has been disproved, or it has said that it doesn't apply anymore. But that progressive thought is contained again in Antil, and Antil really can't only be seen as a judgment for people who've not been taken into custody during investigation. If one reads the judgment, there are large parts of bail jurisprudence that is very well set out in the judgment, which says that bail is mandatory, jail is an exception. And this brings us in sync with other common law countries, Tarun. Please note that our bail jurisprudence, which transcended from English bail jurisprudence, and also is a similar bail jurisprudence which is there in Australia, New Zealand, and other common law countries, where there is, of course, even in bail matters, just the way our criminal justice system is, adversarial, and a public prosecutor gives a fight to say that bail is not required. There, in all these countries, judgments after judgments have come, and whatever is the crime, people are granted bail. And this is exactly what Supreme Court is saying in Antil. So according to me, it's a watershed and it's a landmark decision which should be celebrated.
Okay, watershed and landmark decision fit to be celebrated. I'll go to Niharika Karanjawala for a closing comment.
So, of course, I agree with everything that Abhimanyu and Manmeet have said. It is a watershed judgment, and it's also deeply exciting to see a lot of liberty-oriented comments and a lot of liberty-oriented judgments coming from the Honorable Supreme Court. It truly shows how far we are coming to ensure fairness in every stage of the proceedings. And like Abhimanyu also said, it's not simply a question of anticipatory. It also, Antil also lays down a lot of stipulations as to how bail is considered. Like, for example, that regular bail ought to be disposed of within 2 weeks unless there are any exceptional circumstances and interventions. And these things, especially in certain states where a bail application can linger for months on end, you can go without your bail application even coming up. So in this instance, where this is dealing very literally with someone's personal liberty, so important and so close to your very right to life, it is wonderful to see the Honorable Court coming out with liberty-oriented and progressive judgments that back all of this up.
Indeed, much appreciated. As we saw Justice Sanjay Kishan's call judgment, which we discussed today. Obviously, at a time when the global investor community is looking towards India as a place to invest, they also look at these indicators before investing.
Absolutely.
For whatever reasons, if even by in a sense some conspiracy they'll end up in a case, I think spending 1 year behind the bars is not a prospect anybody looks at without being even convicted. That is why it's most worrisome. But I would, time is out, so I would like to thank Advocate Abhimanyu Bhandari, Niharika Karanjawala from Karanjawala Company, Manmeet Singh from Sarafit Partners. Appreciate your joining us on this really important issue. Thank you so very much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.